Hello, you're listening to the TerraLex podcast, where we break down current issues and trends in the legal industry. Join us as we gain valuable insights from our member law firms across the world, as well as from the in-house counsel community and experienced professionals in their field.
Welcome to today's TerraLex webinar, everyone. My name is Nicole Rudner, and I work with TerraLex's practice groups and industry sector teams to enhance collaboration and deliver client-focused content. Today, we're excited. You're going to hear about the California Consumer Privacy Act and what it means for companies doing business in California. Presenting today are Craig Cardon and Rachel Hudson, both partners at our California member firm, Sheppard Mullin. Both have extensive data security and privacy experience, including counseling clients on compliance issues, domestic and international privacy laws, and data breaches. In addition, Craig serves as the leader of Sheppard Mullin's privacy and cybersecurity practice. We will be taking questions at the end of the presentation. You can submit a question by using the function on your GoToWebinar dashboard. And if you have any issues, feel free to chat with me during the presentation. On that note, I'm going to turn it over to Craig and Rachel.
Great, thank you, Nicole. As Nicole mentioned, I'm Rachel Hudson, and this is my partner, Craig Cardon, and we're both members of the privacy and data security team here at Sheppard Mullin in California. Today, we're speaking to you about the California Consumer Privacy Act. We're going to start out with our agenda. So our first topic will be setting the landscape, the general privacy regulation landscape in the United States and globally today, pre-CCPA enaction. Then we will move on to the details of the CCPA, California Consumer Privacy Act. And then finally, we'll run through the compliance program and plan for achieving CCPA compliance at the end of this year.
Great. Thanks, Rachel. And thank you again, Nicole, for the kind introduction and invitation. So we're going to talk about the landscape today. To set the landscape, Nicole mentioned we're all excited to hear about CCPA. I'm not sure excited is the right word. I think the term that might come to mind is trepidation. And some of this comes down to the background that I'm going to give you. And for those of you familiar with GDPR, which I imagine we all are, I want to contrast CCPA with GDPR just in terms of how they came about. GDPR took 10 years to draft. It involved dozens, if not hundreds, of subject matter experts. There were all sorts of situations and incidents of commentary coming in from industry and privacy-related groups. There were working groups that issued white papers on various aspects of it. Like it or hate it, it's a well thought out and clearly defined law. CCPA couldn't be more different. It came out of a dinner party between a real estate developer in San Francisco and a friend of his who works at Google. And they were talking about Facebook and Cambridge Analytica, and the real estate developer, who had more money than I guess he knew what to do with, was talking to his buddy at Google and saying, it's shocking to me the kind of information that Facebook has on us and that they could do that. And the friend at Google reportedly said, you keep being surprised. You wouldn't believe the kind of information we have on you. And that started a discussion. And so this real estate developer, Mr. McTaggart, said, I'm going to do something about it. And he went and commissioned a law to be drafted to put on the ballot in California. California, anyone can get any law passed by getting enough signatures to get it on the ballot and then having it pass in the general election. So he got enough signatures to get it on the ballot. At that point, all of the legislators said, we're not going to let this real estate developer steal all of the attention in what's really become a populist issue. So we'll negotiate with him, we'll take it over and get him to withdraw the ballot initiative, and we'll put something on we'll pass a law instead. This all happened in the course of 72 hours. There were about a dozen people at most involved. Contrast that with GDPR, 10 years, hundreds of people, lots of input. So what you're going to see is a law that has mistaken references, things that don't make sense, and we'll talk about how we're going to figure out those gaps and things that don't make sense as we go along. But where are we before CCPA? So there's no omnibus privacy legislation in the U.S. There are no omnibus state privacy legislations. What we have primarily are industry-specific laws, right? So laws that affect the healthcare industry or the financial services industry, or activity-based laws. So laws that are directed to specific things like emails, text messaging, et cetera. There are no comprehensive laws. There is a patchwork of laws, even within a state, that covers things that may address privacy. For example, I'm arguing at the California Court of Appeal tomorrow on a law that is characterized as a privacy law, but really is a law aimed at avoiding obtaining information under false pretenses. And so that's the kind of thing that's very different from what we see in Europe and throughout the rest of the world.
So as Craig mentioned, we have industry-specific laws. So under current U.S. law, there's three main industries that are more heavily regulated than others. The primary one that I think comes to a lot of people's minds is healthcare, with the federal HIPAA and high-tech laws regulating our privacy. And as I'm sure we've all experienced as patients in hospitals, you get a lot more notices and information and control over your healthcare information. There are also laws regulating the telecommunications industry, the wireless carriers and other communications carriers, and what they can do with your personal information. And then finally, the financial services industry with Gramm-Leach-Bliley Act on the federal level, and then a variety of state kind of mini GLBA laws that regulate, credit card companies, lenders, home mortgage banks, that type of information. So we've seen those kind of higher risk areas and more sensitive personal information areas being regulated more heavily in the United States.
All right, so these are some of the examples of the activity-based regulations, and I won't go into them in detail other than to just reference them. We have the federal CAN spam law that preempts most state laws addressing the subject. There is the TCPA, the Telephone Consumer Protection Act, that really addresses text messaging, telemarketing calls, fax marketing, things of that ilk that have very, very high penalties embedded in these. And then we've got FTC guidelines dealing with behavioral advertising. The key thing and the important thing to remember here for purposes of interpreting CCPA is that the U.S. is primarily an opt-out jurisdiction. There are very few situations that require opt-in consent. And the text messaging, the TCPA is one of them, and marketing to your kids under 13 years old is another one. Absent those two, with a few other smaller exceptions, we're really living in the U.S. in an opt-out world. And CCPA doesn't change that. And so it'll be a distinction between CCPA and GDPR that we'll get into.
So to contrast that with some of the other laws in other jurisdictions where it really is a comprehensive, omnibus law or regulation. So we've talked about GDPR, which was passed in 2018, covering much of Europe. And that, again, it's not activity-specific or industry-specific. It's all personal data, which is a very broad definition. You can see some other examples here, like in Canada, they have PIPEDA and a variety of other privacy laws, CASL covering email and other marketing activities, and as well as a variety of other countries. And so that's to contrast the current U.S. landscape where, as we mentioned, it's this patchwork of industry and behavior versus these laws which just govern personal information. So, and I think it's helpful to again, kind of talk about this a little bit to get some context on CCPA and why, for the U.S., it is such a sea change, right? Because ultimately, with all privacy laws, it's all about notice and choice. But when we look at most other comprehensive regimes, privacy regimes around the world, GDPR being the most obvious example, what does notice and choice mean? It means as the consumer,
I'm going to be able to find out what information you have about me or you would like to get from me, and I have a choice I get to tell you what you're going to do with that information or what you can't do with that information. Traditionally in the U.S., there's been notice and choice, but it's a different type of choice. So in the U.S., we're going to tell you what we're doing in our privacy policy. If you don't like it, you have the choice of shopping or going elsewhere. That is turned on its head to some degree with CCPA, which for the first time in the U.S. says that the consumer is able to not just say, I'm no longer going to work with you or no longer give you my business. The consumer is able to direct the company in terms of what they're able to do with their information.
So that leads us to CCPA. So Craig and I are both Californians, so obviously we think it's worth it. But when you talk to people outside of California, they want to know, what are you guys doing? And so just as Craig mentioned, it's a big difference in what we've seen traditionally for U.S. privacy laws, although there are still common threads in terms of the concept of opt-out and the concept of you can just, hit the highway.
And just to be clear, I was born in New York, so I'm not
born in Boston. Yeah.
Well, I'm not on board that this is all okay. I think it is largely crazy, but I think we'll work through it. We'll get it all worked out. It is what it is. And I think an important takeaway is that it's not ending in California, right? So California, this statute is being viewed as a model act for many other states. There was one in New York that was ready for the governor to sign. He did not sign it this session. It's coming back next session. It's very similar to CCPA. There are others percolating around the country.
Washington and Texas right. Of all places.
Right. So we should expect more of this. It's going to become more business as usual.
I just meant the sun was worth it. I grew up in New England, I will deal with heavy regulation to not have to dig my car out in the winter.
Yeah, right. So the argument is I actually told our governor that if they keep passing law, we can't continue to get by on our looks as a state in California. At some point, business is going to leave if we continue to impose a lot of these regulations on it, or at least don't explain why they are beneficial for consumers and businesses. And I think there is a way that we'll get into to talk about how it can be beneficial for business as well. But first, we ought to talk about what businesses does it apply to. Well, it applies to you if you're doing business in California. And there is a threshold, right? So it doesn't apply just to anybody. There's a revenue threshold of $25 million, but it's not $25 million gross revenue or turnover in California. It's $25 million in global turnover, or information collected by 50,000 people, or you get 50% or more of your revenue from selling personal information. And one of the keys here is the reason you've got the 25 million, but the other two, the 50,000 people and the 50%, are really targeted at ad tech companies operating that are startups that may not have that type of revenue, but live and breathe in this space of essentially data brokering and data processing. So you also have to collect personal information. And personal information is very different from the traditional U.S. concept of personal identification information. We'll get into that a little bit later, but basically, personal information is everything. It's everything it is under GDPR and more.
All right, and so I drew the short straw, and I have to tell you about consumers, which of course changed Friday, which was full disclosure after I'd already completed our slides. But so you think consumers, that's obvious. They're people who buy stuff at your stores. Of course, it's not. And so the word is consumers, but the definition basically says people who live in California. So is it consumer or is it a person who lives in California? That question was very unclear and uncertain. We now have clarity, and it's okay. So the good news is that under AB 25, and I think it's AB 1355, which passed, they clarified that certain of the provisions do not apply to employees, contractors, and people the employees of the businesses you do business with. It does not apply except for the notice provisions, but that provision of the law will expire after 1 year. So basically, for the first year, employees, vendors' employees, contractors, other people who you would think of more as, in a business relationship, but still individuals, those people are only in scope for notice for the first year, but then they will be fully in scope for everything starting in the second year unless the legislature takes some other action. So to kind of speak long-term, consumers is going to mean everybody in California.
So the good news is anybody who hasn't been as on top of this as maybe they should have been in getting ready, you've got an extra year to get ready for purposes of your employees. For non-employees, true consumers, it really is this January when this goes into effect. I'll tell you, this is an example of, sometimes it's better to just not say anything at all. So what happened was the statute, as Rachel described it, is somewhat vague. You could look at it on its face and it seems to apply to everybody. If you look at the actual text of the statute and what you're supposed to do and what one would assume consumers are, there's a very strong argument, if not a stronger argument, that consumers don't include employees. So some trade organizations went to the legislature and tried to introduce legislation that would clarify that it didn't apply to employees. That request is made to basically a single-party legislature in a state that is experiencing a populist revolution. And you're going to these legislators who are up for re-election this year or next year and saying, do you want this law that's getting all sorts of attention to apply to all of your constituents or just some of your constituents? And so you knew what the answer to that was going to be. On the other hand, if you had just let it go through the way it was, there was a very good chance that if this was interpreted by courts, the courts would say, no, it doesn't make sense for consumers to be employees. Consumers are consumers. As a result, by raising it, the legislators again passed this law that said, yeah, just in case you're wondering whether we thought about it before, we're not going to tell you whether we thought about it before, but they're clearly in scope now, but we'll give you a year to get ready for it.
Yeah, they basically took the amendment they drafted and then added at the end, but it expires at the end of the year.
Right. This one I won't spend any time on. We've kind of talked about it a little bit, but personal information is everything, right? It is unique identifiers. It's typical healthcare information. It's your commercial information. So in your records, you make a transaction, and this is a little more complicated one. If you're a retailer, the fact that a transaction occurred in RMS or your retail management system, that in and of itself is not personal information. But the fact that Rachel made that purchase is PI. So you're able to maintain the information, and this is getting ahead of ourselves, but there are deletion requests. You're able to essentially maintain the information for your inventory purposes that you had a transaction and you sold the unit of that item, but it has to be disassociated from the fact that you sold it to any particular individual. And then the other things are fairly self-explanatory.
Oh, Craig, could you talk about olfactory information?
No. I promised a number of people that I would not talk about olfactory information. I'm waiting. The regs are going to come out at some point. And maybe the regulations from the Attorney General will tell us what olfactory information is.
Smelly database.
But that's another one we'll get to in a little bit. That with all these gaps in the law or these areas where we don't know what it means or what the answer is, we're going to get information about it. And that's going to come from the Attorney General. The Attorney General has said you're going to get regulations on this 7 months after the law has become effective. So we'll talk about that timing a little bit more later. And there may be drafts of some of these regs coming out sooner than that. But it is, again, a distinction from GDPR where you knew everything years in advance. Here, it's a framework for a law. You've got to comply with the law, and after the law is in effect, we'll tell you how to comply with it.
And one of the other amendments that actually is quite helpful that passed last week, and all of these now have to make their way to the governor, so they're not law yet, but the expectation is they'll go through. But it's the clarification that anonymous information and aggregated information, to the extent they don't actually identify anyone, that is not included as personal information. So I think that clarity actually that was one of the helpful amendments. So there are exemptions to I won't say to the law. There are exemptions from basically what's included as regulated personal information. So excluded is PHI, so protected health data subject to HIPAA, Gramm-Leach-Bliley Act data, so financial information that's regulated by Gramm-Leach-Bliley Act, or information that's basically sold to the credit bureaus as part of credit reporting. But the important distinction here is that doesn't mean like, oh, I'm a bank, I comply with Gramm-Leach-Bliley Act, like great, I don't have to deal with CCPA. That's not how it's worded. It's only the information that's governed by those rules that is pulled out of CCPA. So if you have other information that is not governed by one of these other regimes, then that information is in scope for CCPA. So it doesn't pull the business out, it pulls the specific information out.
Right. So what does it do, right? It clearly adds rights, which we need to study, because that's what drives the action plan here. How do we comply with it? It depends on what the consumer rights are. And there are essentially 5 rights that come out of this, right? And I'm going to describe them a little differently than this slide does. So the first is you have to tell people in your privacy policy the type of information, the categories of information that you collect and that you may share with others. So that's something that's you do it, you need to update it from time to time, but it's a one-shot deal. Essentially, it goes into your privacy policy, and it'll go out to your employees when employees come into scope. The next is then anyone who's subject to the Act can make an access request. And this is not too different from an access request under GDPR. The biggest difference is you're able to ask for only the information that the business collected about you in the last 12 months. So it's not all of your information forever, it's in the last 12 months. The biggest problem we found with that is that most companies don't have a date stamp or don't have an easy way to track when they collected information. So more often than not, what we're seeing is the access that is being provided is access to all of the data that we have on you, or that's the plan. The next, and these work together, right? If I'm a consumer, I ask for access, I can see what information you've got on me, I see the categories of information you generally collect. I can then make a determination whether I want you to have that. And so I can issue you a deletion request. That deletion request is not like a line item veto where I can say, I want you to delete this piece of information and not that piece of information. It's either all in or all out. And we'll talk in detail about the mechanics of that, but it has to be a verified request. And so, for example, both of these two, both the deletion request and the access request. So, for example, what if I pretend I'm Rachel and I ask for access to all of her information? I get her credit card number, I get her social security number, and suddenly online, I'm now Rachel. We don't want that to happen. So there are verification requirements for the requests that allow us to say, all right, we need to determine who you are. There are a number of processes out there for doing that. There's several vendors out there that have workable solutions for this. It's the same for deletion. You know, I might not do it for identity theft, but I might do it to prank my buddy and delete all of his information at his favorite retailer. That is, again, still subject to a verification process. Then there's the opt-out of selling, right? So this is what we call the opt-out button or the opt-out link that is going to go on. It has to go on everyone who's subject to the Act's homepage that says, do not sell my information. And selling, as Rachel will describe in more detail, is more than just selling. It is essentially sharing it for any business purpose other than for strictly your own processing purposes. And then finally, there's no discrimination. If I refuse to provide you with my information, or I make an access request or deletion request, you can't discriminate against me and treat me differently because I haven't given you as free reign over my data as you may have previously had.
Yeah, and I think just to add 2 things, Craig, on that problem of not wanting to share information with someone who shouldn't have access to it. That we've also talked with clients about masking certain information so that basically you can think of it like, I wouldn't really want anyone sending out a full credit card number in response to an access request, but maybe you send the last four in compliance with like FACRA, for example, or same with a social security number, a truncated number, so I know, okay, it's my United card. I know that's that one. That is my social security. It's because it's the last four, but no one else could really use it.
That's right. And this is really the nuts and bolts of compliance, right? It's really easy. It's easy to just say you got to give people access to this information. It becomes a much more complex issue when you get into it, and am I right? Am I really going to send that information to them? How am I going to send that to them? There's another California law that says you shouldn't be transmitting an unencrypted social security number. Now, if I have your social security number and you've asked for access to your information, which law do I comply with? And so the solution is this truncation process.
Yeah. So kind of on the flip side of the rights to consumers are the obligations placed on businesses who are subject to CCPA. So as Craig mentioned, it's providing notice. We've talked a little bit about employee notices, but another element to think about is physical stores and you're interacting with consumers and collecting information in stores. So how you'll give notice in that situation as opposed to an e-commerce situation, which is it's a little easier on a website, but providing that notice prior to collection. There are also requirements around the provision of financial incentives. So I think we're all familiar with hitting a website, you get a light box that says, give us your email, we'll give you 15% off. That's okay to continue doing, but now you have to make sure that you're providing all the material terms of that offer by that field where you're requesting that information. Additionally, there are obligations around the selling of information. So honoring that opt-out, you need to have a process to not only collect the opt-out, but then to honor the opt-out and prohibit the selling or sharing of information that has been opted out. And finally, updating the online privacy policy. So there'll be changes to privacy policies on websites to add in all of the new information that's required under the law, including how to exercise all of these different rights. And I think initially that's one of these items that you think, oh, that's easy, no big deal. But once you start getting into the mechanics of how these requests will work, if you you request your data to be deleted, there's a lot of consequences to that. For example, not being able to use your account anymore. And so there's kind of a bit of disclosure to make as part of that privacy update that will be more significant than I think people are necessarily anticipating.
Yep. Great. I'm going to go off script a little bit, and on this slide, I'm really going to talk about do not sell and the relationship between the third parties when you're not selling, or when someone exercises the do not sell right, and third parties with respect to a deletion request. And they're two different groups, right? So for the do not sell requirement, someone says don't sell my information. It means don't give my information to a third party, either for money or where you're getting some business benefit out of it. Now, that's really limited to a third party who's not just your individual processor, who's not a vendor, who's just your processor. So if I'm sending email lists to a vendor that manages my own email messaging and manages that list for me, doesn't give it to anybody else, they're my vendor. That's really not subject to do not sell. On the other hand, if I'm giving data to an ad network, okay, and what am I getting back from that? The overall network is improved. There's more data in it. Or I'm giving data to a co-op database, right? So that information is pooled with information from other parties, and it's being used not just for me, but others are getting a benefit from that information as well. That's the type of information that really is at the core of do not sell. Contrast that with a deletion request. You're only required to delete your own information. So you delete the information you have in your systems, but if you've got these vendors that are processing information just for you, right, and it's not the ad network that's using it for the benefit of others as well, but it's just for you, then you do have to go down the line, reach out to that vendor and say, you need to delete this information because it's considered to be the company's information, not the vendor's information. It's a pretty fine distinction, and they are mutually exclusive, right? So data subject to a deletion request is going to always be treated differently than data subject to a do not sell request.
And we won't spend too much time on this when we've talked about the different notices that are needed, but again, you'll be providing the categories of information that are collected, the purposes of use for those categories of information. You have to tell consumers about their right to have their information deleted, as well as the information that they can request so that they can ask about the categories of information collected, sources, purpose, third parties that it was shared with, as well as, and this is in red, the specific pieces of information that were collected. So you have to tell someone, we collect name, address, phone number, but you also have to tell, if they request it, you also have to tell them, and this is the information about you that we have. Rachel Tarko Hudson, you work at Sheppard Mullin, that level of detail about that individual. And again, as we mentioned before, just a reminder it's not just your websites. There may be other places where you're collecting information, and you have to give consumers notice at or before the time of collection.
And one last thing on this to remember is a lot of people ask, can we just do one notice, right? Can we just put all of these different kinds of notices together? The short answer is no. Because they have to be in different places and they have different purposes. The longer answer is no, but they should be consistent, and they will likely be, some of them will be subsets of the others. So if you have physical locations, you have to have one type of notice that's got certain information published or posted at that location. That'll likely be a subset of what's in your privacy policy. For do not sell, you have to give them information about do not sell, which will be, again, a subset or consistent with what's in your privacy policy. So short answer, no. Longer answer, what's going to be in your privacy policy is really going to drive what's everywhere else. Then how do you respond to these requests? So this circle, this vicious circle is really related to access requests, and we'll distinguish between access and deletion for these in a moment. But so first, it's got to be a verified request. So you go through this verification process to figure out who the person is, and it's usually kind of done as the equivalent of a double opt-in. So you send a confirmation email to the email address that you have on record, or otherwise communicate with them to confirm that that person is the one who made the request. Then you look at, okay, it's the did I collect information on you in the last 12 months? This is a gating one. We talked about it before, that the only thing you need to give them is the information you collected in the last 12 months. Sometimes you can't do that, but what you can determine is, I don't know when it was exactly, but I haven't collected any information about you for 2 years. If that's the case, then you don't have an obligation to respond. You don't have an obligation to provide them with anything. So how long do you have to figure this out? You have 45 days under the statute to respond to a request. You can get a 45-day extension. It is unclear whether that extension, how that timing works, whether it comes at the end of the period or the beginning of the period. So I like to think that 45 days should be more than sufficient for these things. So I would, as a best practice, I stand by it should be done within 45 days. Again, then it's to cover the last 12-month period. That is what's required, but as a practical matter, you may be providing more information because you may not store it chronologically.
And GDPR, you have 30 days to respond. So this is actually shockingly more generous.
Right. And one of the big questions is for both the access requests and the deletion requests, are we going to do this on an individual basis, on a manual basis? and have protocols for doing it, right? So you designate someone or a group of people to respond to these. You give them protocols. You run the following query in this database. You pull out, you extract these data fields. You run the following query in this database. You then combine all these together. Or is it an automated process? And to some degree, it largely depends on how many of these you anticipate getting, what systems one may already have in place from GDPR, and can this be tacked on to that to address this as well?
So I actually want to back up a little bit on financial incentives because I think it's kind of paired with discrimination. And I think initially there was a lot of concern about loyalty and the discrimination provisions of CCPA. And this is actually one of the amendments that actually it just sort of fizzled. It didn't go anywhere, so it wasn't voted through, but it also wasn't voted down, which was to specifically take loyalty out of the statute. And while it seems like I've had clients ask, basically, do we have to offer a service without collecting any personal information so that we're not discriminating against a person who doesn't want us to use their personal information? And the answer to that question is no, right? You can't have a Facebook account and not provide an email address and a password. That it couldn't work. And there's no obligation to provide a personal information-free environment for someone who wants to be deleted. That's not how it works. And for loyalty, we have yet to encounter a loyalty program that we felt was discrimination under the law, because most loyalty programs are not reacting. It's sort of, you can opt in, you get to do loyalty, or you can choose to not be part of loyalty, but it's just a benefit being provided by the company.
Right. And apparently Mr. McTaggart, the original author or catalyst for the law, is a member of several loyalty programs that he likes very much, because he very quickly, when loyalty became a question, went into the legislature and testified that it was never his intention for this to affect loyalty programs. He wants his United Miles.
But so when you are offering a financial incentive, which is, I think, a good example is that window box that shows up on most websites, provide us with your email address, we'll give you 15% off. So you have to notify the consumer of the financial incentive program and include the material terms. So provide your email address. It has to be a new email address, not on our list. The code, we'll send you a code. It's good for this, purchases wherever and for whatever period of time. And you also have to provide the ability to opt out. So you opt into the financial incentive, but you should be able to opt out. And for any email program, that you should be doing that already, right? You can sign up for email, but then you can, of course, opt out under CAN spam at any time. But that would work the same for loyalty. So you have to sign up. You can't be automatically, entered into loyalty, and then you can choose to cancel your loyalty account at any time.
All right. So again, this is kind of the biggie, right? The do not sell. We've talked about it a few times. We'll talk about it a few more times. If someone is looking for what's the easiest way to spot non-compliance, it's looking to see if a do not sell link or button is there on the homepage. So I would tell you, if you're doing nothing else, this is the most important thing to do. I'm not going to tell you should do nothing else, but if you're only picking one thing. So the requirement is that there is a link on the homepage in a conspicuous location that the person can click on and say, don't sell my information. We've talked about what selling means. It means sharing. This is only applicable to California residents. So what do? You've got a website that's accessible everywhere in the world, or maybe it's just your U.S.-based website. Well, how do you parse through this? Well, there are a couple of ways of approaching it. One is you can talk to various vendors who say, we will geofence this, right? So, or really it's more geolocate. We'll identify whether the person is coming from an IP address that is associated with a server in California or not. And if not, we can either not honor the request, which is a risky thing and not a very good customer experience, or we can simply suppress the link so that those people don't see it. That's parsing through it pretty finely, and it works. It should be legal. Most companies that we're talking to are saying, we either can't do that or we don't want to do that. We don't want our New York customers to feel like they're second-class citizens. If we're going to offer it to California customers, we're going to offer it to everyone. So again, those are choices. Is it a link or a button? The language in the statute is link, but it also says conspicuous. There's a lot of debate going on right now about where to put it. Can you put it down at the bottom of a homepage where you've got links generally to a privacy policy, terms and conditions, about the company, et cetera? There's an argument that that is conspicuous. It's where in another law, Cal OPA, it says your link to the privacy policy should be describing that as being a conspicuous location. On the other hand, that was 20 years ago. And since then, there's been a lot of decisional authority that says something is not conspicuous on a website if you have to scroll down to it. And so we are advising that there is a level of risk to putting it down at the bottom. To avoid that risk, especially because this is the low-hanging fruit, it should go up top. Whether you do it as a button or as a link really just depends on your creative folks and how it comes out and how it fits in best with your website. A button can look more conspicuous. So if it's in a very busy area with a bunch of other links, you may want to decide to go with a button rather than a link. If it's held out there on its own, a link is sufficient. We've also seen folks do it that are planning to do it kind of like a cookie banner, where it exists up at the top. You've got to actually click to get rid of it, and then if you scroll down and come back, it'll come back up. Or if you start a new session, it'll come back. The final point on this one is, what's the content behind the link? There's some vendors that'll provide that process for the verification, but the language can really be the same as the privacy policy, which essentially tells you, click here to go to a web form to opt out, or utilize this telephone number, and this is required, to have a telephone number where you can call in to be opted out of selling.
So we've been talking about it, but the effective date is January 1, 2020, so a few short months away. There is this 12-month look back that Craig mentioned. So starting January 1, you'll have to provide information about what you have done right now and this past year. Very helpfully, the Attorney General regulations need to be final by July 1, 2020, which is also when the Attorney General can begin enforcing the law. So that timing is obviously not ideal. We've also had this discussion about just because the Attorney General is not actively enforcing in the 6 months after July 1, can he bring enforcement actions for conduct that occurred during the first 6 months? And our belief is he can, and what else would he do on July 1st? But look to who had been violating the law up to that point.
And just to be clear, there's no restriction on him enforcing the law prior to July 1. He's just publicly stated that he doesn't have an intention to enforce it prior to July 1. And he's left the door open for him to, again, as Rachel mentioned, issue enforcement activity for conduct that occurred before July 1.
And so there, the penalties that are available, and again, and we've been talking about the Attorney General, there is no private right of action. All enforcement will be brought by the Attorney General. There was an amendment at one point to introduce a private right of action, but that basically died in committee. At this point, it could be reintroduced next year, but we haven't heard anything specific on that. So right now, just Attorney General enforcement. The fines are up to $2,500 per violation and $7,500 per intentional violation.
So this I think, is an important piece of it, right? So if that amendment had passed and there is a private right of action for most of these provisions, and there is a private right of action that we're going to talk about at the end, which I want to make sure we get to that. But if it was for all of the pieces of it, everyone would be increasing their California litigation budget tenfold. The slide I use when I'm talking to companies about this is an image of the state of California sliding into the Pacific Ocean under the weight of all of the class actions that will be filed. So breathe a deep sigh of relief. Don't look at $2,500 and say, oh, that's not too bad. $2,500 per violation, $7,500 per intentional violation. The California Attorney General has the ability to decide what is a violation, right? Is it storing information in an inappropriate or a violative manner? Is it just not responding properly to an individual request? Is it per day in which you're not in compliance? So if it's responding to individual requests, it could add up, but it's probably not going to break the bank. If it's per day, again, after your first day, it's usually considered it's intentional. So you're talking about $7,500 a day. Real money, but maybe, depending on the size of the company, not an existential crisis. $7,500 for every individual's piece of information that you have, that a company has in their systems, is an existential issue. And where this is such a populist matter, I think it's not beyond the pale to expect that the Attorney General will be looking for large fines going forward.
Yeah, especially with the bar being set by GDPR. So our final agenda item for the day is talking through what a CCPA compliance project looks like. And so basically this is a lot, and I've seen the deer in the headlights look. So basically you break it down into phases. Phase one, you start with diligence. So looking at what are we doing, what information do we have, what's in scope, where is it going? But basically understanding that data collection, use, sharing, selling. Second phase is remediation, so addressing any gaps that you find in your diligence. Phase three is documentation, so coming up with those policies and procedures to both show your compliance program and also to be able to comply consistently going forward. And then finally, I've had a number of compliance folks internally at clients reminding their business folks, this is not like, oh, good, we did it, January 1, yay. You have to maintain the program to continue, make sure you know new information. You have to update your privacy policy every 12 months. There will be regulations and enforcement actions coming down that will require companies to adjust. So that ongoing maintenance piece.
And I'm going to skip over this other than to say this is an enterprise project. Make sure you've got all the relevant groups in the organization included, just because I want to make sure we get to the data breach provisions at the end and save some time for questions.
So phase one diligence, as I mentioned, looking at what information you're collecting, who do you share it with, and then what are they doing with it? Are you selling? Which a lot of people, the answer is like, no, we don't sell data. But then as soon as you start explaining what selling means, this exchange of information for value, sharing for value, that brings in a lot of things that people just, speaking English would not call selling. And then finally, looking at what does the company want to do? So making sure that if there is a plan to do something, in Q1, Q2 of next year, that we're capturing that now so that we're prepared and the business is able to do what they want to do.
Phase two, remediation, which is really the big step, right? This is where IT has to get involved, where you're putting in place all of the processes for responding to these various requests, how you're going to handle it, who's going to handle it, et cetera.
Yeah, and I think this is an important one because I think a lot of companies will get this response like, oh, legal, this is a legal problem, you do it. But I can't tell you how to delete data from your system. I can't, I could come up with a plan, but it may not work because, well, we have information in 5 places and your plan only said 1 place. So you do need that really heavy involvement from your IT teams, your marketing teams, your systems teams. And then finally, documentation. So coming up with those notices we talked about, financial incentives terms, the privacy policy update, the do not sell website information, all of those different notices and communications to consumers. coming up with internal guides for how, what a request comes in, who will field it, how, who else needs to be involved, where will it go, coming up with form responses to consumers in response to those requests, determining, how much human involvement there will be in each phase, how much customization there's able to be done throughout the process. So coming up with those policies and procedures internally on your back end, those responses, and then the upfront notices for collection. And
then just ongoing maintenance, right? It doesn't end. This is, consider it your annual checkup, or probably better yet, consider it your every 6-month teeth cleaning. Nobody is doing the same thing with data today that they were doing 12 months ago. Push that forward, and if you don't go through this and update your practices, you're going to, I almost guarantee, you're going to be out of compliance within 12 months.
So we mentioned before that there's not a private right of action under the law, and so that's basically covering everything we've talked about until this moment. What I think is kind of the headline that I think some people are really missing under this is the statutory damages for a data security breach. And so I think this slide is really helpful, dating a millionaire, 1 in 200, but 1 in 4 companies experience a data breach. And so now the calculation in that is the risk is much, or not the risk, but the damage is much higher because of the statutory damages for data security breaches in California.
Yeah, so this is really going to be the big effect, right? Basically the private right of action kicks in where one has not basically taken standard data security steps for securing information. That basically is a negligence standard. So it's turning negligence into a statutory penalty. You also have to think about this: if you're not processing deletion requests, if you're not processing do not sell requests, you've got data you shouldn't have. That's the type of that data is. Those are the headlines in the lawsuits that will be filed, right? Not that you had a breach, but that you had a breach and data was exposed that you shouldn't have had. Now, this is a game changer. I want to really emphasize this. So I litigate data breach class actions around the country all the time. My frequent flyer miles are going to go way down. I fly to Ohio on Thursday for one of these. I fly to Atlanta next week for one. I'm never leaving California again. If you are a plaintiff's class action lawyer in the U.S., there is a data breach in the U.S. It invariably will involve California consumers, right? It's just the size of the state. Where are you going to file that? Are you going to file that in Ohio or in Atlanta, where you've got to actually prove damages and half the cases get thrown out because the damages are speculative, they haven't actually occurred yet, or you can't determine it on a class-wide basis what the damages are or what the effect would be? California gets rid of all of that. You don't have to prove any damages. You get a minimum of $100 per person per violation. In a data breach class action, that's going to at least be per person. $100 has traditionally been the ceiling. You will find very few data breach settlements that provide more than $100. So even Equifax is $121, but nobody actually gets the $121. The ceiling currently is now the floor in California, going up to $750 per violation. These are existential numbers when applied to data breaches. If you're a plaintiff's class action counsel, there is no reason for you to be filing it anywhere other than California under this statute if you have a choice. And you may even forget the rest of the country and the consumers in the rest of the country because this doesn't apply to them, because it's going to be so much easier. You've got such a bigger pot of gold at the end of the rainbow under this. So I think this is ultimately going to be the big issue and have the biggest effect. What does it mean? It means up your cyber insurance policies, right? Make sure they're in place. Make sure you're comfortable with the coverage. Make sure that you're comfortable with what your InfoSec team is doing and that they are up to date. If there's any budget leeway anywhere, this is probably the place to put it in to get some return on your investment. With that, we've got a few minutes left for questions.
Thank you both. We did receive some questions. Our first question is who gets the money from fines that are collected? Is it the state, the Attorney General, the individual?
Under the Attorney General violations, the great state of California gets those funds. It goes into the general fund. There's not a segregated fund for this.
Perfect.
Under the data breach provisions, it does have a private right of action. That minimum of $100 per person does go to the affected parties. It goes to the individuals.
And their lawyers.
And their lawyers.
We have a question. How much new money was given to the Attorney General in California to implement this law? How many new full-time employees were needed?
We've got a graphic for that. 0. No money, which is why the Attorney General has said, and it's an interesting one if you actually look at it in the legislative history, it basically says there's going to be no cost effect to passing this to the actual state. So no money. There is a general increase in funding for data security and privacy related issues for the Attorney General. So staffing is increasing, but frankly, it's different than in other countries where you are just doing that work. They will move people from, if we've got very limited antitrust enforcement, the people in the antitrust section at the state, but a lot of data security and privacy work, they're just going to be moved over. But it is why the Attorney General has said, I don't have the time or the staff to get regs out to you all by January 1st. That's why it's going to come in July.
Next question is that you said that privacy policies should be updated every 12 months. Is this going to be monitored by the authorities, and does the CCPA lay out any expectations for yearly modifications that should be done?
Yeah, so it's not should be, it's must. So the law specifically says you have to update these notices every 12 months. And for most privacy policies, that'll be really easy to do because it says the date it was the last modified at the top. And so there certainly could be monitoring. There's also tools online to see when websites have been updated. They can also, if you get, if you're being investigated for something else, then they can just ask you the last time you updated your privacy policy, and if it wasn't in the last 12 months, like boom, automatically you've now violated the law. So that's a kind of I don't want to say easy because it is a lot of work, but there's clarity, and you can set like a calendar reminder and just make sure you're doing that.
Yep.
We have another question. Is there an appeal process to fines by the Attorney General that allows a defendant to go to court?
Yes, there is. There always is, and in fact, the process would be the Attorney General would issue a violation or tell you they're issuing you a violation, try to negotiate some resolution, and sometimes do it just independently that way. Other times agree to a resolution, file a complaint in court, which you've agreed to, and then immediately it's dismissed and there's a judgment that's put in place for the amount of the fine. There's also the ability to say, forget it. I don't think we were wrong. Tell the Attorney General that. He'll file a complaint if he thinks he's got what it takes to back it up. He's got the evidence to back it up, and you litigate that, right? So it's not the Attorney General that ultimately determines it. It will ultimately be a judge in these instances. This would not be a jury trial absent the data breach provisions. For Attorney General enforcement, it would be a judge trial.
Yeah, and actually the first step is they issue an enforcement letter. You get 30 days to correct that issue, and then you move to looking at penalties.
Yeah, now with similar statutes that have this, they'll issue you a notice to correct, and that's prospective, but oftentimes they still look at you for penalties for past violations. So that notice to correct shouldn't be viewed as we'll wait until it happens and then it's a get out of jail free card.
That's a good point.
And our last question, the 50,000 people threshold is stated as consumers, devices, or households. Consumers means California residents, but devices is not expressly limited to devices in California, and households is not defined at all. Are you aware of any territorial limitations on devices and households similar to consumers, i.e. should devices and households be read as limited to devices and households in California?
This is one of those drafting issues where, you know, it's the, I'm not even sure if it's the inclusion or the absence of an Oxford comma. But the interpretation, general interpretation is there is a California limitation on devices and households. This is not intended to apply outside of California, and frankly, there would be jurisdictional issues if California tried to extend its reach that way.
Well, that is all we have for today. I want to thank Craig and Rachel. Thank you both so much for this very informative and thorough presentation. We at TerraLex very much appreciate you sharing this knowledge with our membership. The slides and the recording will be shared following this presentation. And of course, if you would like to know more, you can certainly reach out to Craig and Rachel directly. Thank you both and have a wonderful rest of your day.
Thanks, everyone.
Thank you.